Former presidential candidate Robert Kasibante, who placed 6th in the recently concluded January 15th presidential polls, through his legal team knocked on the doors of the Supreme Court, seeking to amend an application tied to his pending election petition challenging the victory of President Museveni. Kasibante asked the court to compel the Electoral Commission to produce a comprehensive list of all polling stations where voting occurred, along with the certified copies of declaration of results forms from each of those stations.
This one is an application for discovery. All that is stated in the petition is in no way going to be touched. Rather, the aim of the application is to aid court to come to a just and fair conclusion after conducting its duty under the Presidential Election Act, Section 61, to conduct an inquiry. There is no better way to inquire than to find out the whole truth, especially where in such a case like this one, the respondents in many ways are conceding to errors.
However, the legal representatives of the three respondents, President Museveni, the Electoral Commission and the government, opposed the amendment request, urging the court to reject the application.
The respondent who is supposed to answer 3 days later must know the case against me at the time he files an answer. Yeah. So, the documents they are requesting in this application are not in any list, and therefore they are not entitled to rely on them.
The fatal irregularities and irregularities in this petition and application, but it's our contention that it will be a waste of this court's time to adjourn this dead horse and give it more time.
But this application of an adjournment is most undesirable. We pray that this court does be pleased to dismiss the application for the adjournment.
The Supreme Court unanimously dismissed Kasibante's application to adjourn the day's proceedings indoors, where he had hoped to point out specific areas for recovery of the documents.
It has been decided by the court unanimously that the application for adjournment be dismissed, and that we shall then proceed to hear the main application. The main reason for this is that we have very strict timelines, but we'll give a detailed reasoning in the ruling that will come subsequently.
Instead, the justices directed all parties and their lawyers to attend a scheduling conference later in the afternoon or the following day. The goal, to file a joint memorandum and submissions ahead of the court's next sitting on Friday, February 3rd.
The parties and their counsel are going to meet either this afternoon or tomorrow and do a joint scheduling memorandum. And then on Friday, that joint scheduling memorandum will be filed in this court. That is Friday, 30th of January. On that same day, 30th January, the applicant will file submissions in the application together with that joint scheduling memorandum in the main petition. Then the submissions, once filed, should be served on that day, and on Sunday, which is 1st of February, the respondents will file their written submissions in respect of the application. And thereafter, we shall convene on the 3rd of February at 10, so that we complete the scheduling, to iron out the residual issues from your joint scheduling memorandum. And then it is on that day that we shall give you directions on the hearing of the main petition, and at the same time, that very day, that's when we shall hear this application.
David Ijo, NTV.